Hello, this is the lecture on Lesson Module 5, Crime and Criminal Law. Here are the learning objectives, things I hope you'll be able to do by the time you finish this module. We'll start out by defining the word crime. I know it seems like it's pretty intuitive. We all know what we mean when we say crime, but this is an academic study of crime. And so we want to start the basics and make sure we really understand what we mean and how the word crime, what it really means and how it kind of started. Here is a illustration of like a bullseye graphic. This is in your textbook, so you may have seen this before if hopefully you've already read chapter 5, but this is in there. But I want to go over it with you because it really does help drive home some points. Look at the bullseye or the circle there, and you see it's kind of at that tan color here. You can see my mouse kind of rolling around. So if you look at the whole circle, this whole circle is supposed to represent all possible harmful acts imaginable. Even the slightest bit of harm is included in this circle. Crime then is a subset of all possible harmful acts. So to analyze it, you got to move in from the big circle down to the smallest circle. So here's your big circle, all possible harms. And just inside of this here is all social harm. All right, so if you're narrowing it down from all harmful acts to the types of harms that you could sue somebody over. So there are certain harmful acts that no one would never be the basis of a lawsuit, like bumping into someone in an elevator. There's that slight momentary contact, unwanted contact or unsolicited contact that happens accidentally. You would never sue somebody over that. But when you go to further in, you're now grouping social harms, and you could sue somebody over that, but it would be a private lawsuit. It wouldn't be something that we prosecuted as a crime. So this would be, a breach of contract or a negligent act that resulted in your injury that was totally an accident, but the other person had a duty of care, and so you can sue them to cover your medical expenses or something. That's social harms, moving in, making the circle just a little bit smaller, as you would, if you could look at it that way. But within that, now we're getting into this layer here. This includes crimes, all crimes. So anything that society would punish as an offense against the state or an offense against all people. So any act that is offensive enough that a particular culture would define it as criminal and prosecute it and punish it. And then the smallest little circle there in the middle are known as core offenses. So core offenses are harmful acts that all cultures would condemn across all time, all geography, everywhere. This offense is a crime. It is offensive, morally repugnant to the state. There is universal outrage against it. High consensus that this is a criminal act, that it should be punished to the highest level of punishment. Okay, so now when you were doing, you should have done this assignment first before you even cracked the book to look at chapter 5. I asked you to create your own little crime continuum, to actually draw it by hand. And what I was wanting you to learn from that is the way people sort of naturally group harmful acts. I asked you to do it as a continuum because it's a little bit easier, but just to graphically represent a whole possible harmful acts, you're supposed to kind of attach along the continuum. But you probably noticed some patterns developing as you did that that are similar to the patterns in this bullseye illustration here, where there are certain offenses that are, the most possible harmful offenses are all grouped down at one end, and there's fewer of them, but they're the worst things that you could think of. Those would be the core offenses. And then way down at the other end of your continuum would have been all harm, like the whole circle, all harmful acts. So minor acts that you wouldn't even sue somebody over, just minor temporary discomforts created by an accident, for example. So that assignment was intended to kind of show you how these patterns naturally developed across all cultures over time, the way we kind of have naturally grouped harmful acts and created this subset of things that we will prosecute. If you remember, let's look back at that graphic for a second. Rene Garofalo, or wait, it was Raphael Garofalo. He had applied the evolutionary perspective of natural law and showed how human choice has sort of created its own understanding of what crime is. And crime would be those acts that harm the evolution of the species or the survival of the species. Those would be your core offenses, your mala in se, bad in of itself acts that all cultures across space and time would punish. So that mala in se is the same thing as saying core offenses. And then mala prohibita, what Garofalo described as mala prohibita, is defined by its context of time and space. It is morally repugnant to certain cultures at certain times. So that is a crime, but we don't consider them core offenses because they aren't universally condemned. Okay, so now what is criminal law? We've talked about what crime is. What is criminal law? Just like crimes are a subset of all harmful acts, criminal law is a subset of common law. Let's see if I can get to the right place on the. Yeah. So criminal law then started out as a subset of common law that defined crime and punishment. That's how it worked out. So it was judicial decisions based upon the norms, beliefs, values of a specific culture. Those traditions were applied in law, and the reported decisions developed until you had a subset of common law that dealt with crimes and criminal punishment. It was handled at the state level. Crime began as a very location-specific area of law. Every state kind of had their own way of doing things, but patterns emerged, as you saw, where all states kind of had certain laws that prohibited core offenses. Okay, so it's mostly state law. It's probably 90% state law, but most states' criminal laws are very, very similar because these patterns naturally develop. There is some federal law involving crimes. They're usually the basis of violating statutes, so federal criminal statutes. Not very many of those. Most of it is state law. There is a body of procedural law that is only applicable in criminal prosecutions. And that's something we're going to study in the next learning module about criminal procedure. But for now, we're just talking about the substance of crimes. And so I said it started out as common law, and these patterns developed where, all states and jurisdictions kind of had very similar, if not identical, rules and laws about what crimes were and how they should be punished. So legislation followed. The legislation codified the common law principles of crime and punishment and made them into codes. So there'll be a state criminal code in every state in the United States of America. And it all came from, it was just the codification of common law principles. And they're very, very similar state to state. So much so that legal scholars got together and created a model criminal code, or model penal code, I think is what it may be called, because it's just very similar. And most states kind of base their criminal statutes off this model, just how they were writing it. But it all started at common law and then it became codified as legislation. So now you would go and look at the criminal code of your state to see what is defined as a crime, what punishments are associated with it. Okay, now we're going to talk about how you prove a crime. So if you were a prosecutor, how do you go about prosecuting a crime? What do you have to have? What kind of evidence do you have to collect? What do you have to prove? For every crime, there are 5 necessary elements that must exist. All 5 must exist at the same time, or you cannot hold a person criminally liable. So we're going to go through what those 5 things are. First is actus reus, it's Latin action. The action element must be there. Something is done. Mens rea, something is done with a certain state of mind. So you got a defendant in a certain state of mind doing something. That's actus reus plus mens rea. All right, they must concur. So the concurrence of the mens rea and actus reus is its own element of criminal liability, something the prosecutor has to show, the concurrence of the mens rea and actus reus. Then causation, the actus reus, mens rea concur and cause harm. And harm can be physical or mental. So those are your 5 elements: actus reus, mens rea, concurrence, causation, and harm. You need to memorize that. All right, let's go through them with a little bit more detail now. Actus reus, when you're proving the action element of a crime, you're more or less just showing that the defendant's contact was voluntary. They were not sleepwalking. Sometimes there's certain duties to act, things that a reasonable person simply must do because of the relationship they have with the victim. For example, the easy example is parents. They have to take care of their children. If they neglect their children, they've committed a crime. Okay, that's just an example of a crime that comes from failing to act. There's a few of those. Sometimes just possessing something is a crime. You would think of drugs there. The mens rea element is the mental state of mind, and you should not confuse it with motive. Motive is why someone commits a crime. And it has to be, technically doesn't have to be proven, but it often is, because it makes the whole thing more believable to a jury. But the state of mind is something separate that has to be proven separately. And it's proven in levels. So there's a person's state of mind could be one or more of these things. And I've got it, levels of intent. This is important. I organize this a little differently because I learned this differently than your textbook presents it. In law school, I was taught a certain way of how to analyze mens rea, and I think it makes more sense. So I'm going to show you the way I learned it. It's slightly different than your textbook. As far as the levels of intent go, you start out with purposeful. This means it's planned. You not only intend to do the act, you intend the harm that comes from the act, and you planned it. You thought it through. You knew what you wanted to do. You knew how you wanted to do it. That's purposeful. Knowing is the state of mind where you know what you're doing in the moment. You haven't planned it. The opportunity presents itself to harm someone, and you know what you're doing, and you know the harm. You intend the harm, even though you didn't plan it out. It just sort of happened. The situation presented itself, you knew you wanted to kill someone and you did. For example, I'm using murder as an example, but this is could be true for any crime. So that's knowing what you're doing, intending the harm that is caused. The next is the heat of the moment. And in this situation, it's you intend the action, you intend to do the act, but you don't mean the harm that you cause. So it's kind of separating the intention to act with the intention of the consequence. So with the heat of the moment type state of mind, you don't intend the consequence, but you mean to do what you're doing. It's voluntary. And you know that it is likely to cause harm, but you don't intend the actual consequence that occurred. Recklessness is very similar to heat of the moment. And so in the context of murder, this would be, both of them would be considered manslaughter, heat of the moment and recklessness. That's manslaughter. But heat of the moment is voluntary manslaughter because they are choosing to do the act. They just don't mean the consequence. They don't mean the harm. With recklessness, you don't even really mean to do the act. But you were just taking such a risk that you should have known that this was going to hurt somebody. So that's a slightly lower level of intent, but both manslaughter. Then the last I have here is negligence, which is just not acting at all when you should. Okay, that's its own level of intent. There are some crimes that can be proven without the mens rea element. They're known as strict liability crimes. They will always be statutory mala prohibita offenses that they usually involve handling extraordinarily dangerous objects. The idea that comes to mind is like having a dog, dog bites. The owner of a dog is strictly liable for harm caused by the dog. So they don't mean for anything to happen. They didn't actually do it. It's just they had a dog that was violent, dangerous, and they didn't restrain him as they should have. So that would be a strict liability offense. There are probably better examples of that. I just want you to kind of to know in the back of your mind, there are some offenses where mens rea doesn't matter. Oh, a statutory rape. There you go. An adult man is strictly liable for being prosecuted or being liable for rape if he has sex with a minor. Okay, so that's mens rea. Concurrence is self-explanatory. The mens rea and the actus reus coming together. And the causation, that is where you're proving a sequence of events. So the harm that the victim experienced would not have happened but for your action, the defendant's action. That's called factual causation. It just kind of, one was the most likely consequence of the other. But there's also an element of legal causation. And here we're getting a little bit beyond the scope of the class. But with legal causation, you're talking more about intervening events or where a lot of time passes between the actus reus and the harm. And so much time that the harm wasn't really foreseeable. It may be factually connected in the chain of events, but it was so far down the chain of events that it wasn't really easy for the offender to know that harm was going to result. So that's legal causation. The prosecutor has to show that it was foreseeable that to the offender that if he or she did this thing, harm would result. And so then the last is harm. That's your last element. And as I said, there are some crimes that just involve mental harm. Not many, but there are some. But mostly it's physical harm. The prosecutor has to establish there was a victim. All right, so those are the elements of criminal liability. All crimes require proof of those 5 elements. But even after that, so even assuming that the prosecutor has established all 5 elements, there are still some limitations on what and how the crime can be prosecuted. Due process should jump to your mind when I say that, because the due process principles of the Constitution that we kind of breezed over a little bit in Module 3, we're going to talk more about in Module 6. Those limit the ability of prosecutors in the process of prosecuting a crime. There are also some substantive limitations as well that we'll talk about in other modules. Some types of behavior cannot be defined as criminal because to do so would violate a person's freedom, goes too far to limiting an individual's freedom. That is the basis of some of the fundamental rights case law that we kind of briefly mentioned in lesson module 3. When you think of due process, you probably automatically think of the Bill of Rights, and that's fine. But there are some limitations in the original Constitution. Bills of attainder were pieces of legislation that sort of convicted someone of a crime without a trial. And it's very hard to think of examples of a bill of attainder, but I want you to just think of it as Congress or state legislature writing a law, and the effect of the law is that a group of people are now criminals. Automatically, they've become criminals because of the law being passed. That's a bill of attainder. Those are prohibited by the Constitution, the original Constitution, not just the amendments. Then you have ex post facto laws. Those are prohibited also in the original Constitution. Think ex post facto meaning after the fact. So you can't punish someone for a crime that was defined after they committed the act. So if something is legal when it's done, Congress can't go back or a prosecutor can't wait for Congress to make that act a crime and then go back and say, hey, you did this a year ago. I'm going to prosecute you for it now because now it's become a crime. Can't do that. That's a violation of the Constitution, original Constitution. There are some limitations as well in how crimes are defined. This would be a problem for Congress or the state legislatures. Crimes can't be broad or ambiguous. That would be a violation of due process, actually. It's explained separately in your textbook, but it is its own sort of analysis. When you are writing your statute, making some act criminal, you have to be specific and clear so people know what is a crime. They have to know what they're doing is defined as a crime. And the last one here, really more to do with punishment than criminal, prosecuting crime. How you punish someone is limited by the 8th Amendment as well. Okay. Another pattern you probably saw emerge as you were making your crime continuum were the types of crimes. There is a sort of a naturally occurring typology. I bet far kind of grouped on one end of your continuum were crimes involving harm to an individual person, crimes against the person. Those are more offensive and morally repugnant than crimes against property. So crimes against the person would include anything where an individual is harmed: murder, rape, assault and battery, robbery. Then crimes against property, those are kind of less serious crimes. There's still a lot of damage. You still go to jail, but the harm is caused to property, not people. Theft, burglary, and arson are the ones that we'll look at. And last, you'll have, now you're getting towards the opposite end of your continuum. You have mala prohibita, crimes against public order or morality. They are not core offenses, not mala in se. These are mala prohibita crimes that, certain cultures and certain times may have prohibited. but it's not universal, and it usually changes. An example would be sodomy. So there was a time in the United States where sodomy was considered a crime, and people were prosecuted and punished for it, but not anymore. It's not considered that anymore. So it would have been a mala prohibita, a crime of morality, but morals change. And so um, now it is not considered a crime, and there's actually constitutional protection um, for that prevent states from prosecuting sodomy as a crime. That's just one example. There are others that may be in this PowerPoint later. I can't remember. Okay, we're going to look at the individual crimes now. I'm going to go through this kind of quickly because this is intuitive. Here we're getting to things that everybody already sort of knows. You may not have seen it organized in this fashion, but you guys will, this comes easily. What is murder? Killing somebody. We know that. Okay. So the definition at common law, killing a person, and then there's this phrase, malice aforethought. What the heck does that mean? That's just your mens rea. You kill a person with a certain level of intent. Okay, so let's look at actus reus, duh. That's the big duh factor. Death. Someone is killed. The mens rea are your levels of intent, and it's in statutes now, they're considered degrees, like first degree murder, second degree murder, and so forth. So you have these different degrees of murder, and they're based on whether your mens rea was purposeful, knowing, in the heat of the moment, reckless or negligent. Those are your levels of intent. They kind of emerged as degrees: murder in the first degree, murder in the second degree, and so forth. So your mens rea and actus reus come together, and they concur in causation. It causes harm, and the harm, obviously, is death. There are some modern adaptations of the common law definition of murder, but it's just something that happened in the shift from common law crime to statutory crimes, where the definition, the words were changed essentially. But modern life also has created new issues, new questions, such as when does life begin or when does life end? So has murder been accomplished even if someone is on life support? I mean, we have amazing advances in medical technology that can keep people alive that 10 years ago would have been a death sentence. They would have died. So can you still prosecute someone for murder if they are still living on life support? You know, when does that end it mark? What do we end it with? Does there have to be absolute death? The victim is buried, not on life support. That depends on your jurisdiction. And when does life begin? So that's going to depend on the development of abortion laws. You know, do we see that unborn child is alive? Then if you kill the mother and the child dies as well, have you committed two murders? So that is going to depend on your jurisdiction and your belief about when life begins. I wanted to do a separate slide about the levels of intent of murder because I think it'll help you understand what they are, generally even. So you can kind of extrapolate this and apply it to other crimes as well. But we'll look at them with murder, and I've got some pictures on here that'll, if you watch the movies and maybe pay attention to the news, you might have heard of these. So first degree, so in the statutory law would be called first degree murder. In common law would be purposeful. These are premeditated crimes, lying in wait. If you saw the movie, The Shawshank Redemption, there's the scene that Tim Robbins' character, whose name I cannot remember right now, in that movie and the book, it was a Stephen King book, he sat outside his home knowing that his wife was in bed with another man at that moment. And he sat there and he sat outside the car and plotted what he was going to do about it. Now he was drunk off. Yeah, he was pretty drunk. But he brought a gun. I mean, he knew what he was going to do. So that's a premeditated murder. But then you have Morgan Freeman's character who robbed a convenience store, and somehow in the process he shot the clerk, but he never meant to. That was not planned. But he was put in jail anyway, and so the two characters meet up, and it's an amazing movie. I recommend you read it. I mean, well, read the book, watch the movie. So Morgan Freeman's character, that would have been second-degree murder. He knew, what he was doing. Might have been manslaughter, depending on whether he really intended to kill the shop clerk or just hurt him. So manslaughter would be those next two sort of levels of intent: a crime of passion. Let's say you're in a bar, you've had too much to drink, someone offends you, says something really mean, you all get into a fight, and you just happen to be extraordinarily strong. Maybe you box for a living or something, and you hit too hard and the other person dies. Well, that's a crime of passion because you were caught up in the heat of the moment. You did not intend to kill anyone by what you were doing. You intended to punch him, but you didn't intend to kill him. So that's manslaughter, not murder. But recklessness can also come into play, such as you might think of vehicular homicide, DWIs resulting in the death of another driver. That's recklessness, or involuntary manslaughter is another word for it. But you're just kind of moving down from this high level, first degree purposeful intent. Now you've come all the way down to manslaughter. Recklessness was your state of mind. And then last is negligence, is when you have a duty to protect someone and you don't, and they die as a result of your negligence. You see the picture of the young lady there on the screen. I'm sorry, I have forgotten her name. I do remember what happened. It was in Texas. It was maybe 5 years ago, 4 years ago, where she was texting with a young man. He was extremely depressed and suicidal, and she kind of coaxed him into completing the suicide, and he died. So they prosecuted her for murder, and I'm not sure what degree or how it was exactly labeled, but that's an example of recklessness. She knew or should have known that by counseling him in this weakened state of mind, he would follow through and kill himself. And so she was prosecuted, I believe convicted of involuntary manslaughter. Felony murder is something I think your textbook talks about, and this is where murder occurs in the course of a crime. It wasn't planned, though. So let's say a group of people decide they're going to rob a bank, and while the bank robbery is going down, a bank teller challenges one of the robbers, and he gets upset and shoots the teller. Everybody who was part of that robbery can be prosecuted for the murder that occurred during the course of the robbery, even though they never planned it, didn't intend it, and didn't actually kill the bank teller. Only one of them did, but they're all on the hook for it. That's called felony murder. All right, our next one is rape. We all know what it is. The common law definition, though, is a little wacky. Long ago, rape was defined as carnal knowledge by a man of a woman, not his wife, forcibly and against her will. Carnal knowledge means a certain type of sexual activity, the standard type, vaginal intercourse. So any other type of intercourse wasn't defined as rape. Had to be a man against a woman, could not be a wife, his wife, because legally that husband would never be prosecuted for raping his wife. It has to involve physical force and be against her will. So the focus of that definition often came to be the victim? Was the victim asking for it? Was she beaten up first? How hard did she fight back? Prosecutions unfairly involved a focus on the victim and not on the offender's state of mind. But that changed. So modern definition now, this is the actus reus element, carnal knowledge with force outside the scope of the marriage. So when we're talking about carnal knowledge, you're just talking about I think I have this messed up. I'm sorry. Let me go through this just a second. Okay, I'm pairing this with the common law definition. So at common law, old times, the actus reus involved carnal knowledge outside the scope of a marriage because a man could not be prosecuted for raping his wife. And the mens rea, again, was focused on the victim. Was it against her will? Did she fight back? The modern form, now I've got it straight. The actus reus is any unwanted sexual contact. It doesn't matter whether it's standard sexual activity, any unwanted sexual conduct or contact, excuse me, is enough to satisfy the actus reus element. Mens rea, now, modern time, we focus on the offender's intent, not on the victim. So did the offender intend to make that sexual contact? If he or she did, then it's right. So, yeah, marital status completely is not relevant anymore. You can prosecute a man for raping his wife. Gender is irrelevant. It's not about male, female anymore. It's I think most often called criminal sexual assault. I think if you look in most state codes, rape is actually called criminal sexual assault because it's has nothing to do with gender, has nothing to do with marriage. It's just unwanted sexual contact. And the degree to which force was applied doesn't determine whether or not it's rape. It actually just determines what grade of the offense, the level of intent, or the amount of punishment someone would get may be affected by whether they used a gun, some sort of weapon, whether they used a drug, whether they beat up their victim, that sort of thing. It's always going to be rape regardless, but you may serve a longer sentence. So it'd be aggravated criminal sexual assault depending upon force. Concurrence is always going to be an element, as is causation and harm. Okay, next, assault and battery. At common law, assault and battery was defined as unwanted physical contact that causes harm. So the actus reus involved some sort of physical contact. When contact did not occur, the offense was just called assault. When contact did occur, it was called battery. And that's why I've grouped it together. In the common law definition, I'm just grouping it together. If actual contact occurred, it would be called battery. If it didn't, it would be called assault. You could prosecute it either way. It just had a different label. Mens rea would be the same as with murder, those same levels of intent. Here, it's just the intent to hurt someone, not to kill them. Concurrence, causation, and harm is always an element. Harm now, so now they're grouped together. Assault and battery comes together, and I can't recall at the moment how most codes, what they call it. But regardless, what we're dealing with is some sort of unwanted physical contact, not sexual contact, unwanted physical contact. And harm can just be mental injury. It doesn't necessarily have to be a physical injury. You can assault someone with your words, with your threats, whereas battery is going to involve physical harm. And if you use a weapon, It's called aggravated assault and battery. The severity of the injury may also affect the type of punishment that is applied. Okay. The last one we have for crimes against person is robbery. And I want you to pay close attention to the definition of robbery. It hasn't changed a lot. Common law definition is the taking of property from the person of another by force or threat. So it's still taking property, but you're taking it from a person, okay, with force or threat. So the actus reus is taking from a person with force or threat. The mens rea is you intend to take the property away from them. You intend to go away and keep them from having it again. Then the last three elements always there: concurrence, causation, and harm. Modernization really has to do with the grading of the offense. Extortion is threat of future harm. So it's robbery, but you're not threatening to hurt them right immediately. You're saying, I'm going to hurt you if you don't give me your car. Like a carjacking well, no, it would be, I'm going to hurt you if you don't give me money, and I'll hurt you in the future, if you don't give me your money. So future harm is extortion. Robbery is present harm. So the harm's going to come immediately. Now, notice I've shifted from crimes against person to crimes against property. Larceny or theft is taking property, but you're not taking it from the person of another. You're just taking it away. So you're taking property, carrying it away with the intent of permanently depriving the owner of it. But there's no threat of harm coming to the person. You're not threatening them to hurt them physically and personally. You're just taking the property away. That's the actus reus element. The mens rea element is the intent to permanently deprive them of their property. And concurrence, causation, and harm are always the elements. Mens rea, the modernization of larceny involves intellectual property. Technology has allowed a lot of changes in terms of intellectual property, taking people's ideas, taking people's identity. Those types of things are included now in the statutory definitions of larceny and theft. That didn't exist at common law because the technology didn't exist at common law. So that would be the modernization of it. There is grading to it in a lot of state statutes. The value of the property taken will determine the grade of the offense and the extensiveness of the punishment. Okay, next we go to burglary. This is an obvious crime against property. At common law, you had to break into a home at night with the intent to commit a felony therein, which usually meant taking away their property, taking their stuff. It's a little different now. But let's see. Yeah, we're going to go through the common law definition, though. Actus reus is unlawful entry. The mens rea is the intent to enter and commit a felony while in the place. And concurrence, causation, and harm always there. But in statutory codes, the modern version, it does not have to be a home. It can be any structure. Doesn't matter if someone's there when you break in. It doesn't have to be at night anymore. But you do have to have the mens rea and actus reus coming together. And remember, the mens rea includes the intention to commit a felony while you're inside the structure. So it's not just trespass. You're not just breaking in. You're breaking in because you intend to steal from somebody to take their property away. That's what changes it from larceny to burglary. Arson is the next one. You know what arson is? It's burning, right? So common law, you were burning a house. Now you're just burning a structure. That's the actus reus element, setting fire to a structure. It does not have to be a dwelling place, but you have to intend to burn it. So you planned it, or you knew what you were doing at the moment, or you were just being stupid and you are burning a structure. That's arson. Concurrence, causation, and harm are always there. You cannot, by the way, you cannot negligently commit arson. That's one thing that's unique to it. It isn't setting fire to a structure by accident. That's not arson. So we have to be purposeful, knowing, or reckless. And there are grades to the offense depending upon whether someone is present when the burning occurs. Okay, next you have these are crimes against public order or morality. These are your malaprohibit offenses. In Garofalo's analysis, he's categorizing it this way because these are offenses where there's a low consensus as to whether this is punishable or not, or should be punishable or not. Some cultures punish it, some cultures don't. Some cultures punished it in the past, but don't now. That makes it a malaprohibited offense, a low consensus that this harmful conduct should be punished. So it's often crimes that were based on a culture's definition of what is and is not moral. They could be referred to as victimless crimes, but no, I'm not sure it's necessarily victimless. There's usually an impact, a negative consequence to the behavior, but it may not be directed at a specific individual. Some common offenses were breach of the peace, are. There are breach of the peace statutes in every jurisdiction that involve like fighting, disrupting public order. Unlawful assembly, meaning an assembly without getting a license first from the city. Prostitution, that would be considered a crime against public order. Sodomy, as I said, not a crime anymore. So definitely not a core offense ever. Never was a core offense. But it used to be punished, but not anymore. Drug use, definitely a malaprohibited crime. And it is still punished. There's some discussion in your book, and if you know much about history, you'll know that these, particularly the breach of peace offenses, were abused a lot. The powers that be would arrest political protesters, claiming that they were breaching the peace and public order when really they were just exercising their freedom of speech. So it's easy to abuse that particular one, and it has been abused in the past. These offenses are often challenged constitutionally because they impact freedom of choice. When there isn't a specific intended victim, it's just considered offensive to the public or to the community. Oh, that's where you kind of got to balance individual freedom and public safety and decide, this is going too far towards infringing a person's freedom of expression or freedom of choice. So these types of offenses are somewhat often challenged as a violation of substantive due process. All right, next we're talking about, and it's a fancy word, inchoate. It just means uncompleted attempt. All right, you can be prosecuted for attempted murder, attempted rape, an attempted robbery. Anytime you have the specific intent to do a criminal act, and then you take some step in furtherance of that intent, you've committed the crime, even if you didn't fully complete it. So let's say you're a bad guy and you walk up to a woman in a dark parking garage with a rope in your pocket and a gun in your hand. We know what you intended to do. You intended to kidnap and harm her, but she had some mace in her purse. She sprayed you. She got away, called the police. You're arrested. So they can't say you're guilty of abduction and battery or murder because you didn't complete it. But you are guilty of an inchoate crime, attempting to do it. So you're still prosecuted even if you didn't complete what you intended to do. Solicitation is a crime. This is, you have the specific intent to induce or solicit another person to commit a crime. And all you have to do is suggest it, say it. So it's those words that constitute the actus reus element, your words of inducing someone, and you intend to induce them to commit a crime. That is solicitation. Conspiracy is kind of like the next step in solicitation. It's when the other person agrees. Once you have that agreement, then you move from solicitation to conspiracy. But with conspiracy, it's more than words. You got to do one other thing. You've got to take one more step in pursuit of this conspiracy. So, an example is often used with this. I've got this scene from The Godfather, and you see the head of all the five families. It's the big scene where they're planning, are we going to get into drugs or not? And they're all together and they form an agreement about it, and they make plans. So any act in furtherance of this agreement makes this a conspiracy, and they can be prosecuted for it. Complicity is not technically an inchoate crime, but the book, and I've got it, I'm kind of lumped in here. Complicity is when you help someone else commit a crime or help them get away with it. So the bottom image there is from another movie that's really good called Goodfellas. And so there was only one guy, Joe Pesci, who actually committed the murder, but you see his buddies there helping him bury the body. Well, they're complicit in the crime, so they can also be punished for it. That's complicity. And it can be helping before the act, like helping them plan and prepare. It could be driving the getaway car or stashing the body, any sort of help. It doesn't matter when in the sequence of events you help them. If you help someone commit a crime, you're complicit and you can be prosecuted. All right, last I've got defenses to crime. So part of being a prosecutor is anticipating how the defendant is going to respond to the prosecution. And so what we're looking at here is, what are the possibilities? What can a defendant do to avoid liability, criminal liability? And the first one I've got up here is to deny it and say, well, I didn't do it. It was somebody else. And they can prove that by showing they have an alibi. They can prove they were at some other place at the time of the offense. So that's one defense. And it's really just challenging the evidence that the prosecutor has presented. There are other types of defenses where you admit, okay, I did it. So you're admitting the actus reus element, but you're reasoning why, even though you did the crime, why you should not be punished or why you should be punished less. Those are called affirmative defenses. So an affirmative defense is separate from just denying your involvement. Here you've admitted your involvement, but you're saying, I don't deserve punishment. So for affirmative defenses, the defendant has the burden. They have to present evidence of an affirmative defense, establishing why they shouldn't be punished. When you are simply denying that you committed the offense, you don't have a burden because the prosecution has the burden to prove those 5 elements of the crime, and you can simply deny that you committed it and then just kind of try to use your attorney to create reasonable doubt, show that you have an alibi, that sort of thing. But with affirmative defenses, the defendant himself has to step up and present some evidence. It could be a justification. Yes, I did harm someone and they didn't ask for it, but I'm not criminally liable because I was acting in my own self-defense, or they consented to the harm, like we're in a boxing match or something. or it is a police officer or parole officer, someone who's carrying out their duties, and those duties required them to use force. Another affirmative defense could be excuse. So, yes, I did it. Yes, it caused harm. Um, I'm not responsible. I'm excused from liability because I was under duress, I was drunk, I'm too young, or I'm insane. Legal insanity. So not mentally ill necessarily, but legally insane. There are a variety of definitions of insanity, legal insanity, that don't coincide with the definition of mental illness. So you just have to be careful there. Um, these pictures that I've got up here on the screen are some examples, real life examples. The man at the top, his name escapes me. Well, I just can't remember his name. I'm sorry. But though he killed a young man for no reason, and he claimed it was self-defense, but he wasn't being threatened. It's kind of a tragic and unusual situation. The law was, I think it's called Stand Your Ground. The law in Florida allows people to justify what would otherwise be murder by saying that they had the right to stand their ground, to not walk away from um, a threat, what they deemed to be a threat. And I've just forgotten. Trayvon Martin was the victim. I just have forgotten the name of the offender. Then below them, you have Ronald Reagan and John Hinckley. And John Hinckley he was trying to kill Ronald Reagan. He wound up killing a Secret Service agent and wounding Ronald Reagan. Um, but he said he was doing it because the actress Jodie Foster told him to do it, or maybe he was trying to impress her or something. But that met the definition of legal insanity. So rather than being sent to prison, he was sent to a mental institution. And I think he may have died there. I don't know where he is now. But that's an example of legal insanity where, yeah, his conduct was criminal, but he's not held responsible because he didn't have the capacity to understand the consequences. All right, that's all for lesson module 5. If you have any questions or something, I need to go over something again, it didn't make sense, of course, you should email me.